Thank you for the opportunity of speaking here. My goal is to make talks about the GDPR as entertaining as possible. And what is better than to start A, with a cartoon, and B, with the objective of the GDPR. So what is often forgotten in the implementation of it is that the overall objective of the GDPR, which stands for General Data Protection Regulation, is to harmonize the data protection rules in the European Union and to reinforce data protection rights of individuals and simultaneously facilitate the free flow of personal data in the single market. So much for the objective. And there is quite a tension between those two aspects. And the cartoon that you're seeing here was shared and I think even drawn by Jan Albrecht, who I think still is a member of the European Parliament for the German Green Party, and at the time when the GDPR was in the making, was the rapporteur of the GDPR, and this is how he depicted it. So the GDPR is there to protect the consumer that pretty much looks like a hipster. I'm just missing the coffee here, who innocently wants to shop and needs to be protected from the evil corporate organizations that basically just want to make money. So what the general data protection regulation aimed to be is to become a jack of all trades, or in German, eierlegende Wollmilchsau, and that is exactly what this picture depicts here. So something that should encompass literally everything where data is involved, and as you might guess, it is bound to fail if something that ambitious is done. So I would say that the General Data Protection Regulation right now looks more like this animal, which was opted by CNN as one of 10 most hideous animals in 2019. However, if you would imagine this little one with a little bit of hair, I would think it is quite cute. And if we can get hair to this animal, then maybe also us as researchers, we're a bit less scared of the GDPR. Now, when we talk about member state implementation or the GDPR, by entering into force in May 2018, it was in effect immediately in the whole European area. However, it also allowed or necessitated some national implementations, and some countries needed to adapt national laws to be in line with the GDPR. And by May 2018, only a couple of days before the GDPR, after 2 years preparation time entered into effect, only Austria, Germany, France, Croatia, the Netherlands, Sweden, and Slovakia were ready. Other countries were not ready, and some said they were ready in a couple of months. In the end, I think there are still 3 or 4 countries to date who have not fully implemented it. And I picked out the Czech Republic that ensured the implementation only in April this year. So what was underestimated by the member countries was how long it would take to allow for the implementation. So you can expect where I'm heading, that is, for research, it is even more complicated, as for research, the GDPR allows derogations, but I come to that a little bit later. Now, what also becomes quite prominent in the GDPR are the national data protection authorities. And again, around May 2018, the then head of the president of the French Data Protection Authority and head of the European Data Protection Board cried out and said only 17 out of 24 national data protection authorities have the resources to actually fulfill the obligations that they're having. And what is this crowd usually saying? It is saying that too little staff, too little funding is available to actually do that. And to exemplify this again with an example, for Austria, there were 3 staff members responsible to monitor and to fill up the Data Protection Authority. By today, it's 12 people. Austria has a population of 8 million people, quite some businesses, quite some research projects. So you can guess how little is still possible with these little resources from this Data Protection Authority. And to contrast this, as I mentioned earlier, the statement from the head of CNIL, the French Data Protection Authority, they are well set up. They have produced quite some nice guidelines over the years to come. And Austria, for instance, same as other countries, are stating, well, go to the CNIL, use their template for the data protection impact assessment. You don't have to, but it is a suggestion because we ourselves, that's what they're not saying, of course, publicly at least, we ourselves cannot produce our own. And on the other hand, it also might not be needed as the CNIL one is relatively good. Now, when talking about the GDPR, it's also always important to exemplify what it should do, and obviously it should protect the individual, it should protect sensitive data, and this is very often not clear. And sometimes I find it's easier to talk in the research context by using an example from something completely different. And you might have heard of sensitive data where secret locations, military bases in Afghanistan became known to the public because data of military personnel was shared. What was the background? The US Army thought the body mass index of the average soldier is not to our liking. So let our soldiers for free use Fitbit, encourage them to share data as much as possible, nobody reading the privacy statements. And eventually, a company had a contract with Fitbit, got access to the data. They thought they were only sharing metadata with the most popular, to identify the most popular routes for jogging. And who runs in a big amount, a lot of people, regularly in a circle? The military, and with the visualization, the secret, up until then, secret military base here in Helmland province was identified. So the takeaway message for this presentation I want to give is whatever you do, there are reasons why there are security measures. Whatever data is shared, there are side effects that we are not thinking about, which also requires from ourselves as well as the lawmakers to avoid disclosing of unintended information as much as possible, and when it comes to health data, to have measures in place against anti-discrimination, especially for employers and security. Now, diving into the law for the GDPR in terms of health data or in terms of special categories of data that reveal racial or ethnic origins, political opinions, religious or philosophical beliefs, trade union memberships, genetic data, biometric data is in general forbidden unless you have explicit consent, the obligation to share, a vital interest to do so, legitimate activities such as unions to do so. It was made public by the data subject itself, him or herself. It is necessary for the exercise or in defense of a legal claim, substantial public interest, preventive occupational medicine, public interest, public health, archiving in the public interest, historical and statistical research. it is the ones that are highlighted in bold are usually the ones that we use in research. The most common ones are explicit consent and archiving in the public interest, historical, statistical research, or if a specific law is there in place in one of the member countries. Important to note is that from the legal basis viewpoint, there is no hierarchy among these legal bases. It needs to be reasonable. Now, safeguards have to be in place, and Article 89(1) says that processing for the archiving purposes in the public interest, scientific or historical researches, purposes, statistical purposes, shall be subject to appropriate safeguards in accordance with this regulation. So the question obviously for us in the community is what is an appropriate safeguard and how to deal with this matter. Now, there is some academic discussion in the field, but in essence, appropriate safeguards is what is state of the art currently in the community and requires constant improvement. So it's not a static concept. I did it once and then it fits for eternity. Data minimization is one of the key elements of the GDPR, so only collect the data that you are really needing. Do not hoard data for an unspecified purpose, so that could be, in some sense, a call for spring cleaning. Pseudonymization is, I think, one of the most tricky concepts in GDPR and in general. I think what is perhaps the take-home message is that whenever we think of pseudonymization or anonymization, we have to be aware that it is a dynamic and not a static concept and depends very much on the context, whether it is within or without the GDPR space. Also, some member countries have different opinions of it. So what most of the European Union countries see as pseudonymized data, the UK already accepts as anonymized data in form of a policy recommendation. However, it is already contested by the European Data Protection Authority, and it is definitely not related to Brexit. So whether Brexit comes or not, the UK committed to implement the GDPR, and anything that continues to happen there, whether they stay or not, will follow the same rules. Well, here is some food for thought. Whatever we are doing in terms of data sharing is also a question of data protection is what are we protecting? And I call this the Nemo argument, because the father, Merlin, has a dialogue with Dory, the fish who constantly forgets everything, that he does not want anything to happen. He wants nothing to happen to his little Nemo. And Dory says brilliantly, well, if nothing ever happens to little Nemo, then anything will happen to little Nemo. That's an odd request, and that is the scary part for non-data sharing. If we are overprotecting, then it is simply not useful. At the same time, when it comes to security measures, be aware what you're protecting. Do you want to keep people out or want to keep data in? And I use here the Japanese paper walls as an image because, well, it might not make much sense to put a perfect high security lock in front of one of these paper walls. Now, the con in consent is when you think of how long it would take for you to read the average digital privacy policies, the New York Times calculated that it would take you 76 working days. And to read out Amazon's terms and conditions alone would take approximately 9 hours, and I'm sure every one of you has done that before. So if you read the terms of use, similar argument, just to print out the several terms of use on paper would lead to a stack as depicted in this picture. So nobody is actually reading it, and it is a legal remedy rather than protecting the individual at times. Now, when we come down to safeguards and derogations, I quickly want to highlight Article 89.2, which is, I think, the most tricky one for all of us, that the member states have the opportunity to provide derogations in relation to the Article 15, right of access of the data subjects to the data, right of rectification, right to be forgotten, or right to be object. Some countries have opted not to do anything. A lot have opted to do something. And there are several legal experts, also nationally, trying to figure out what that actually will mean in practice. And my educated guess is it will definitely take another year until we have clarity. At the same time, data sharing has to continue to happen. Now, what about research? Research in this is a very hard nut to crack, especially to mention something new as well in terms of accountability, but also the link for FAIR, as we've heard it before, to open access and restricted access. The scope in this for us is, of course, health research and the interrelationship between health research today as well as enabling personalized medicine. Research and clinical care, patient-driven data, consumer companies are in the digital age merging, and I think we are not yet mentally ready. So is the GDPR a nice animal? And are we ready for it? Well, it depends. We have to think from a technological viewpoint, legally, and is it socially accepted what we are doing, especially when it comes to data sharing, because what the GDPR is, it's the legal framework. It should not enable or hinder us. It should be kind of the backbone of the things. It has to make sense. What is needed thus is to rethink privacy, because I think, or this is a statement from Klaus Heuer, the privacy concepts that underline our thinking today, as well as the GDPR, come from the 19th century. However, the technological promises are already in the 22nd. And with this last slide, I want to conclude my presentation. Well, as regards to the GDPR and a lot of what we're doing, it will always depend on the context. It will depend on trust. You can have legally everything right. If the underlying trust is not there in the institution, in what you're doing, in the systems that you have, then it is meaningless to follow up. Thank you.